Okay, today we're going to cover two main sections of the real estate exam. The first section is going to be on deeds, grant deeds, trust deeds, deeds of reconveyance, quitclaim deeds, these type of things. And then we're also going to cover ways of transferring title and holding title. And then we're going to talk about some government involvement. So first, let's get started with the grant deed. So we can define a grant deed, this document, as a document that transfers legal title to real property. So a grant deed transfers title to real property. And before we go any further, I want to make sure you're comfortable with OR and EE. So in our world, words that end in OR represent the giver of property rights, real property rights, and EE represents the receiver of real property rights. So for example, with the grant deed, the person giving all the rights and interest in the thing owned from themselves to the other party is called the grantor, and the person receiving all those rights is called the grantee. So this is probably usually going to be the seller, and this is probably going to be the buyer. But I want you to understand that the OR ending words are the giver, the EE are the receiver. Let's just talk about a lease quickly. So the landlord gives the tenant the right of possession, the right to be there. So what do we call the landlord? The lessor. And what do we call the tenant? The lessee. Because again, the landlord is the one giving the property right, and the lessee is receiving the property right. And if we continue that through, when we talk about trust deeds, which we'll go in detail in a minute here, but the borrower, the one that went to the lender for the loan and is willing to deed the right of foreclosure to the lender, is the giver. So they are the trustor, and that's the borrower. And then the third party that holds that right to foreclose, that receives that right, is called the trustee. So the trustee, we might say, is a third party agent. However, they're holding that right of foreclosure for the benefit of the beneficiary, which is the bank, which we'll talk about in a little bit. But I just want to emphasize the point of OR and EE. So back to the grant deed. The grantee transfers legal title to real property. And when you own real property, you have certain rights in that property. You have the right to be there, which we may call the right of possession. We have the right of sale, right? You can sell your property. We have the right of sale. You have the right to encumber, meaning you can borrow money or use that property as collateral, burden that property. And you have various other rights, but right now let's concentrate on these three rights. So when you're going to transfer all those rights you have completely from yourself to someone else, you would use the grant deed in California. And that has certain implied and expressed warranties. And that's why we use it. Before, we actually used to use more commonly another deed called a warranty deed, which kind of got replaced by the grant deed, because now when you're transferring all the rights and interests in the thing owned and these property rights, it's right of possession, right of sale, right of encumbrance, we now protect that right, or at least that there's no defect in this transfer, with something called title insurance. Before title insurance, the seller would give the buyer a warranty deed. That kind of would be the protection, but title insurance is much more protection, because as all insurance works, you pay a premium to protect against uncertainty. If there's a claim that's covered, you can put in a claim to the insurance company. So the title insurance protects this kind of transfer from defect and a few other things. But for our purposes, let's just say that a grant deed is used to transfer legal title to real property. Now, let's talk about what makes a valid grant deed. What makes a valid grant deed? So this document, it needs a few things to be a valid document. The first thing it needs to be in writing. So it can't be a verbal transfer, it needs to be written in writing. It needs to have language in it that says what's going on, and we call that language a granting clause. So it'd be I, Armando, Oliva, grant to Bob Smith for valuable consideration the real property located at XYZ. It needs to have a description, and we might say a reasonable description. So it doesn't need a legal description. A legal description contains lot numbers and track codes and different things like this. A reasonable description basically is assuming this person owns two properties on the same street, that a normal person would know which one we're talking about from this reasonable description. And it needs to be signed by the person giving away the rights, which we said earlier is called the grantor. So it needs to be signed by the grantor. So sometimes on the state exam, what they'll ask is what is not required for a valid grant deed. So you might notice a few things that are not on here that you may think like, well, I thought those might be required. Like notarized. Does it have to be notarized? And the answer is no, a grant deed does not have to be notarized. I'm going to do it in blue because this red's not working well. Does it have to be acknowledged and usually get acknowledged before a notary public? No. Does it have to be dated? No. Does it have to be recorded? And when we say something's recorded, what we mean is at the county recorder's office, the county where it's located, has it been recorded? And the answer is for a valid grant deed, none of these things are required, but these are required. So on the state exam, they may say, which of the following is not required for a valid grant deed? And they may show 3 of these and 1 of these, and you'd have to know that 1 of these are not required. However, in practice, they're done, but not because the law requires them, because the title insurance company says, hey, to prevent fraud and to minimize defects, if you want our insurance coverage, then we're going to need it recorded. And if you're going to record something at the county recorder's office, they require that it be notarized, so that you need to acknowledge the signature before a notary public, and they usually date the grant deed and they mail it back to you when it's been recorded. So grant deed, valid grant deed in writing, granting clause, reasonable description signed by grantor, does not need to be notarized, acknowledged, dated, or recorded. However, by custom and by practice, they usually are, especially when there's other parties involved that are requiring it, otherwise they won't do business with you. Now, the second type of deed that we need to know, when you buy a home, you're going to receive the grant deed as the buyer, but if you need to borrow money from the lender to get that home, you probably are going to also have a trust deed. So we say a trust deed transfers naked legal title to the lender. So the trust deed.
So the grant deed is if you bought it for cash?
No, the grant deed is legal title, here you go. However, if you borrowed money from the bank, in addition to a grant deed that the seller would give you, you would give the lender a trust deed or a deed of trust.
So you'll have both?
You would have both. Now again, it's not that you have a trust deed, it's that you're giving it to the lender, right? You're deeding the right of foreclosure to the lender.
Okay.
With the grant deed, the seller is deeding you legal title.
Got it.
Now, if you bought it cash, then you didn't have to deed the bank anything because there's no lender involved. And the reason we say transfers naked legal title is because this right that you, the borrower, are deeding to the lender is very limited. The bank can't sit in your house waiting for you to get home and cook dinner because you haven't given them the right of possession. The bank can't borrow money against your house because they don't have the right to encumber it. They have a very limited right. That's why we say it transfers naked legal title, because it's stripped of all the major rights and interests that you have, except for one, the right of foreclosure. So it gives lender right of foreclosure. And the reason we use in California a trust deed is because it allows the bank to foreclose on you in what we say a non-judicial foreclosure. And all that means, non-judicial, is they don't have to go to court. They don't have to sue you. In some states, when you have a mortgage, not a trust deed, I know we kind of use those words interchangeably in California, but a mortgage technically is different than a trust deed. And how does it differ? Well, the way a lender forecloses on a mortgage and the redemption period is much different than a trust deed. In California, banks, lenders lend money on real property using a trust deed. Because if they have to foreclose on you, they don't have to go to court. They can follow a certain procedure and follow a non-judicial foreclosure to get their money back from you, hopefully, if there's anything left. Now, the characters or the parties in a trust deed, as we said earlier, are the borrower, which is the trustor. They're the one saying, hey bank, I own this house. I'm going to give you this right that I have in it, very limited, but the right to foreclose. But the way trust deeds work in California is that the lender can't hold that right themselves. It's got to be with a third party. That third party is the trustee. Now, for all intents and purposes, they pretty much work for the lender. They're probably a title company. They could be a servicing company. But the trustee is a third party agent that holds right of foreclosure. And they hold it for the benefit of the lender. And so in this case, the lender is the beneficiary. So the three parties in a trust deed are the trustor, the trustee, the beneficiary. The trustor deeds the right of foreclosure or naked legal title to the trustee, who holds it for the benefit of the lender. Now, if you default on the payments, the lender will then instruct the trustee to begin the foreclosure proceedings. Now, we also say that a trust deed hypothecates, you might hear that word in your studying, hypothecates real property. Now, how does it hypothecate it? All we mean when we say hypothecate is that it makes the thing collateral for the loan while you still get to use it. So if we go to a pawn shop and we leave them our watch and they give us the money, that's not a hypothecated loan because we don't get physical access to that watch until we pay the money back. But with the trust deed, you're living in your home. Can you think of another type of loan where the collateral for the loan you get to continue to use? What's that? A car loan is a perfect example of another hypothecated loan in which a trust deed hypothecates real property, meaning it makes it collateral for the loan. Now, a trust deed can be identified as a few things. We said one, it transfers naked legal title. Another thing, it hypothecates real property. Another thing is we can say a trust deed, I'll write it here, secures a promissory note. So when you go to the bank to borrow that money on that home you're purchasing, or you're refinancing your home, you've already purchased it and you're just refinancing it, the bank's going to want two things when they're dealing with a trust deed. Number one, they're going to want the promise that you're going to pay the money back. We call that a promissory note. A promissory note. And that's basically the contract between you and the lender. But that's just a piece of paper at the end of the day. So what gives it teeth? The fact that you are deeding to the lender, basically, the right to foreclose. So we say that trust deed secures that promissory note, because now you probably are gonna pay because you don't want the bank to foreclose on it. Now, at a certain point, you've hopefully paid off that loan, or you've refinanced that loan and you borrowed money from someone else. So that lender should not have the right to foreclose on you, should not be holding naked legal title anymore. So they will instruct the trustee and say, hey, listen, they paid me off, I've been paid in full, or whatever the case may be. They'll instruct the trustee to go ahead and give you back this right of foreclosure that you as the borrower deeded to them. So the trustee will record, so this is the third deed we need to know about. The trustee will record a deed giving back, a deed of reconveyance for benefit of trustor. So you paid the loan off, the beneficiary will instruct the trustee who's holding the right of foreclosure and say, hey, go ahead and return that back to the borrower who's named the trustor.
See, the
And-
trustor, grantor, lessor kind of throws me off when we come to the trustee because it's the borrow and or, not the
Well,
provider.
but let's stick with what we said earlier. We said that the giver of the property right is the OR. The bank's not giving you any rights in your property. You're giving the bank the right to foreclose.
Oh, okay.
So
Okay,
it sticks
we're the
perfectly
difference,
with our
okay.
logic.
Okay,
So the grantor gives the buyer the legal title to the property. The landlord, the lessor, gives the tenant the right of possession. The trustor gives the bank, sorry, it's a residual from my cold. The trustor gives the bank the right to foreclose.
okay, that makes more sense.
And now that trustee has to return that right back to the borrower.
When they pay it off.
When they pay it off.
Then they just get this document. mailed.
Called a deed of reconveyance,
Okay.
giving back. To reconvey is to give back, convey is to transfer. So trustee records a deed of reconveyance for the benefit of, who's the trustor?
Me.
The borrower,
Yeah,
the
okay.
borrower. So make sure you keep that straight.
Okay.
Now, you can have multiple trust deeds on your house, right? You can have multiple trust deeds on your house. You can have multiple liens on your house. How do we know the priority of liens on your home?
By the date they were started, right?
The date of recordation, the date of recordation. So how do we know that Bank of America is first before you have to pay off Wells Fargo? By the date
I'm
of
thinking of
recordation.
Mechanics lien.
Date of we didn't ask about that. We're asking very simple baby steps here. So how do we know what lien is priority? Well, by the date of recordation. What you're referring to is what's the exception to the priority of liens by date of recordation, and we had learned that a mechanics lien takes effect not when recorded, but when the work began. So how do we, but right now since we're on the trustee topic, how would we know which lender would get paid off first if you have to foreclose and you default? By the date of recordation, And when you've paid off the lender and they should no longer have the right to foreclose on you, we call that the deed of
Reconveyance.
reconveyance. In real estate or in real property, we kind of have a record of ownership, which we can call a chain of title, So this record of ownership pretty much takes back or starts at the beginning of this house. So maybe this house was built in 2000, we know who the owner was, it was sold in 2004, then it was sold in 2006, and here we are in 2018. this chain of title will kind of give a record of ownership. And it's this kind of record of ownership and transfers that title insurance protects, that there wasn't any defect or anything within policy limits. However, sometimes things change, and when we talk a little bit later about ways of holding title, one way is when you're married and you buy that house, you're going to hold title as what we say community property, meaning you both own it 50-50. So when you're married and you buy real property after you're married, the state of California sees it as community property, that it's both of yours 50-50. But very often what will happen in our business is you fell in love here, right? You got married here, and unfortunately maybe things didn't work out, and now you're selling the house here, but the title insurance company comes and says, well, we can't insure this transfer because as far as we're concerned, there's someone else on title. There's someone else, and now there is some kind of cloud on title. So whenever there's some uncertainty onto the exact ownership of real property, we say there might be a cloud on title. So the title insurance company or the buyer's lender or the buyer themselves may say, hey, we can't move forward until we've cleared that ambiguity, that cloud. So very often what we use in our business is another deed. So we talked about grantee, we talked about trust deed, we talked about the deed of reconveyance. Now we're going to talk about a quit claim deed, in which basically the other party, maybe one of the spouses or the ex, says, I quit any claim that I have on this property. And that now in turn removes the cloud on title, and you can continue with your sale.
Can you use a quitclaim deed to add someone to title?
You could, but it's generally seen as that a quitclaim deed has no warranties. So you wouldn't want to necessarily use it when you're expecting to have implied and expressed warranties. That's why we don't quitclaim properties when we sell it. We grant them with an official grant deed. But it's very common that within spouses or sometimes within family members, you may add them, you may quit some of your interest and add it to them.
Got it.
But generally, if you're going to sell or anything like that, you want to use a grant deed because that offers the most protection. And a quitclaim deed is usually used mostly to clear clouds on title. For the state exam, I want you to know it clears cloud on title. But it has no warranties. It says I may or may not own anything here, and I'm quitting anything I may or may not own. So it's not that strong as a title insurance policy or a grant deed, that kind of thing. So we had those 4 deeds, chain of title. Now let's switch gears a little bit and talk about ways of holding title that we might see on the state exam. The first we may call holding title in severalty, And don't get thrown off by the fact that they're saying several, because it sounds like it would be more than one. They're saying sever. So sole and separate. Sole and separate. So what do we mean if you're holding title in severalty? We mean sole and separate, one party. And I say one party because it could be one person, it could be one company, it could be one corporation, so one party. Now, if there's more than one owner, which we may say co-owners, the most common way that co-owners hold title, is as tenants in common. And the word's there, right? Tenants in common. Tenants in common is the most common way that co-owners hold title to real property. It's also the most flexible. We could have different percentages. You could own 90%, I own 10%. You could buy 100%, then sell me 5%, and we're still tenants in common. I could will whatever percentage I have to my family or my kids or my heirs. You could will whatever you have. So it's very flexible, the most common. It only really requires one requirement that we call the unity of possession. And all that means is we can't say that you own, the garage and I own the house. We both own the whole thing, but just different percentages. You maybe own 95% of the home and I own 5%. That's what we refer to as a unity of possession. But this by far is the most flexible way of co-owners holding title to real property.
So unity of possession is just another name for tenants?
It's not another name, it's just one of the requirements for tenants in common.
Okay.
Is that I don't know if you remember that movie with Jennifer Aniston and Vince Vaughn where they buy the condo together and they break up and then he says, I own the living room, and she goes, well, I own the kitchen. And that wouldn't be unity of possession. You can't have tenants in common that way. They could own 50% of the condo and they each own 50%, but you can't divide it up like the bathroom and the closet. That's what we mean by unity of possession. So tenants in common has one requirement, this unity of possession. But the percentages of ownership, when you bought it, all these things can be variable. That's different than the next type of co-ownership called joint tenants. Now, no one says you have to hold it this way. A lot of people are like, oh, why, I don't like that. Well, but if this is important to you, joint tenants has something associated with it called the right of survivorship. The right of survivorship. That basically means the other co-owners have the right to survive you in that piece of property. Not in anything else you own, but related to that piece of property, the other co-owners, if you die, will get your interest. Will get your interest. Not, you can't will it away, you can't give it to someone else, it goes to the other. So if let's say A, B, C, and D own this property as joint tenants, and D dies, well, his 25% is going to go to these guys. Mm-hmm. And so on, and so on, and so on. Now, they all stay as joint tenants when that happens. If for some reason this guy sold his 25% to another person, well, that person would not be a joint tenant. Reason being, to be a joint tenant, we now need to meet 4 unities or 4 requirements that we may call TIP. TTIP. The first T is for time. We must all buy that piece of property. If there's going to be 4 of us, 4 owners, we must all buy it at the same time. We can't buy it today and then sell him 20%, then him 20%, then we're all joint tenants. No. There must be only one legal title with all our names on it. So all our names have to be on that title. Whatever interest we have, meaning ownership, must be equal. Must be equal. So if there's 4 of us, then we each own 25%. If there's 2 of us, 50%. If there's 10 of us, 10%. And then that unity of possession is required also. So these 4 requirements for you to have joint tenants, if you wanted to, and you met these 4 requirements, then you could hold title as joint tenants with right of survivorship. Now, it's important to know that we as licensees don't ever want to instruct the client on how to hold title, but for the state exam, we need to know these different types. So severalty, sole and separate, tenants in common. The most common type of co-ownership really just requires unity of possession. And then we have this joint tenants, which has this right of survivorship, which means the other parties will deed or seize ownership will terminate and the other parties will get that interest. However, they need to meet the TIP, time, title, interest, possession. And then we had talked earlier about the 4th, community property. Community property, which is pretty much for spouses.
So for tenants in common, do they also have equal shares, or they can have?
No, that's the whole point of it.
You're like
It could be
60, 90.
99% and 1%.
Mhm,
They
okay.
don't have the interest having to be equal.
Okay,
It could be any percent.
so that's only with joint tenants or?
Community
married
property.
Community property.
Community property among spouses, it's 50-50.
Mhm.
So one way they might test your knowledge, they might say, what does joint tenants have in common with community property?
Equal ownership.
Equal ownership. Not that it has to be 50-50 over there,
Yeah.
but that it's equal, and here, by definition, 50-50 is equal.
Okay,
So, important to be clear on these 4 ways of holding title. In severalty, sole and separate. Tenants in common, the most common type of co-ownership. However, you need unity of possession, but you can have different ownership interests. You could sell it to other people. You can bring other tenants in common in. Joint tenants, a very specific way of having co-ownership with this right of survivorship. But you do need to meet time, title, interest, possession requirements. And you cannot will it. So you cannot will your interest because when you die, it goes to the others. However, you could sell your interest and that would terminate your joint tenancy. These guys would still stay as joint tenants, but let's say D sold it. He didn't will it. He sold it to E. Well, now E would be a TIC, a tenant in common with these guys. And he could will his interest. Again, no one's telling anyone to have it this way, but some people maybe because they don't want to do wills or trust, and maybe you're doing something with a friend or a relative, you say, listen, something happens to me, it immediately goes to you, something happens to you, it immediately goes to me, we don't have to go to probate, nothing, because of this joint tenants with right of survivors. Okay. Now let's talk about ways that the government can get title to your property. The first is called eminent domain. Eminent domain. And that's the power of government, and I don't just mean the federal government, that could be the state government, that could be a local municipality, but power of government to take private property for public use. However, they must pay the person or the party just compensation. Just compensation. And for our purposes, this might also be referred to as condemnation. So if you see that, just know it's eminent domain, pretty much the result of eminent domain. So the power of government to take private property, but it must be for public use, and they must pay you just compensation. That's eminent domain. So that's one way that the government could take title to real property. Another way is if you die without heirs. Not necessarily without a will, because with a will you could will your thing to anybody, not necessarily your immediate heirs. But when you die without anyone to bequeath your stuff to, we say your property could escheat to the state. So when you die without anyone to claim your stuff, die without heirs, after a certain amount of time, usually it's about 5 years, die without heirs, your property will go to state. This is where every few years you might get an email that says, go on this website, you may be owed property in the state of, California. So that would be that the property is cheated to the state. So an individual cannot get title through his cheat. Only the government can. So you might see a question that says, an individual can get title in all the following ways except, and the answer would be as cheat when you die. But while we're talking about this, what do we call it when you die without a will? We call that intestate. So that doesn't mean you don't have heirs. That just means you didn't write down who you want to get your stuff. You might remember Prince died recently without a will. He died intestate. However, he had a mile long of people that wanted his stuff.
Sure.
So he had a lot of heirs that popped out of the woodwork, but he died intestate. He died without a will. So as far as government getting title to property, I want you to know about eminent domain, and I want you to know about escheat. And another kind of way to transfer title, but not until death, is a will, right? Because a will says, you get my real property upon my death. Just because you wrote the will today doesn't mean they got the property. So a will transfers property upon death. And you might see a couple of questions about wills. So let's talk about two types of wills that we may have to know about. One we may call a witnessed will, and the other a holographic will. And believe it or not, our handwriting is still considered, even my atrocious handwriting, is still considered to be, good evidence that you wrote this will. So if you can think of holographic, the H, handwritten will. Handwritten will. But if you typed it up, or someone typed it up for you, you would need to have two witnesses. But the question might be, how many people sign a witnessed will? And the answer would be 3. The 2 witnesses plus the maker. Plus you, the maker of the will, right? Two witnesses plus the maker or the person who's the will, so it would be 3. So don't get confused if they say, how many people sign a witness will? The answer is probably going to be 3 people. Holographic will, handwritten. And when does property transfer in a will? Well, upon death. Okay. So a quick review, and if you're watching or listening at home, follow along. What deed gives back to the trustor the right of foreclosure? Returns that. The deed of reconveyance. In California, how do we transfer title to real property?
Grant deed.
A grant deed. If there's a cloud on title, how can you clear that up?
Quit claim.
With a quit claim deed. And what was the 4th type of deed we need to know about?
Trust deed.
The trust deed itself. If I buy a home cash, will there be a trust deed?
No.
No. But if I borrow money. Now, what do we call the lender in a trust deed?
The trust,
The beneficiary. The beneficiary. What do we call the borrower?
Trustor.
And what do we call the third-party agent that holds that right of foreclosure?
Trustee.
The trustee. The trustee. If you can get that clear, you'll do great. Okay, that's it for this round. Thank you.